colonialism, fascism, and imperialism have faded away in the 20th century, albeit a few enclaves in Asia and the Third World. International crimes are, however, on the rise. The 21st century marked the steady rise of individuals as subjects of international law, more particularly in the province of human rights and delusion of procedural incapacities before international tribunals. The high watermark of the present century is global commitment towards ending impunity, fixing accountability and criminal responsibility of individuals who commit serious international crimes. Rome Treaty 1998 of the International Criminal Court, which has been ratified by 70 states as in October 2002, has the objective of putting an end to impunity of the perpetrators of serious international crimes and vindicating state obligations to exercise its criminal jurisdiction over those responsible for international crimes. The International Criminal Code, in brief ICC, is complementary to national jurisdiction over persons who have committed serious international crimes defined in the statute: the crime of genocide, crimes against humanity, war crimes, and the crime of aggression once the crime is defined. The ICC is a permanent court to investigate and bring to justice individuals who commit the most heinous crimes under international human rights and humanitarian law. The ICC was created on the basis of the Rome Statute, a treaty adopted in July 17, 1997 in Rome. Its main objectives are as follows. Number 1, the code seeks to end impunity. The philosophy behind its creation is that there can be no peace without justice. Number 2, the ICC prosecutes individual offenders, not the states. Number 3, political leaders and ordinary soldiers are prosecuted like for grave offences under the ICC statute. Number 4, it prosecutes for the gravest international crimes such as war crimes, crime against humanity and genocide. Number 5, it follows the principles of complementarity. The ICC is the culmination of more than 5-century-old human exercise towards imparting individual criminal responsibility of natural persons who had perpetrated serious international crimes, starting from the war crime trial of Peter von Hagenbeck, a high official of Charles the Terrible, the Duke of Burgundy in 1474 AD, who used state territories in putting the populace of Becek to abject surrender. Several international conventions adopted in the period from 1884 to 1936 fairly established the norms of individual criminal responsibility. State practices has recognized individual as subject of international law. The Rome Statute of ICC provides for comprehensive framework of prosecuting, investigation, holding trial of, convicting and punishing individuals, the natural persons, not the abstract entity personified by the state or government or any office who has committed the crime, as enumerated in Article 5 to 8 of the statute. The ICC can exercise its jurisdiction over persons for committing the most serious crimes of international concern as referred to in this statute and shall be complementary to the national criminal jurisdiction. The objective of determining individual criminal responsibility would be achieved with the active international cooperation of states, which are otherwise completely sovereign subjects of international law in the true sense of the term. The ICC is yet to evolve its jurisprudence on the basis of decision, whereas the Appellate Chamber of ICTY in 1995 TEDIC case made out a point of war crime being perpetrated in admixed situation of international and internal armed conflicts. It is important that emerging ICC jurisprudence would incorporate the TEDIC precedent in its decision-making process in future. Considering the fact that in a vast majority of contemporary global armed and conflict zones, the watertight characterization of international or internal armed conflict is receding. In several post-war situations, the interlocking of a war crime and crime against humanity has also been found to be a reality. The experience in working of the international humanitarian law and the commission of grave breach of Geneva Conventions has given evidence to this interrelationship. The individual criminal responsibility has been further crystallized by the Rome Statute. Article 27 has rendered the official capacity of the criminal irrelevant. A head of state government, a member of government or parliament, an elected representative or a government official has not been exempted from one's criminal responsibility, and he or she need not be awarded reduction of sentence, and no impunity in official capacity would be given by the court while exercising its jurisdiction. No exemption has been accorded to military commanders. The ICC statute stipulates a military commander or person effectively acting as a military commander shall be criminally responsible for crimes within the jurisdiction of the court committed by forces under his or her effective command and control. The Geneva Conventions of 1949 and two additional protocols of 1977 also provide for commanders' responsibility for committing grave breach of Geneva Conventions. The violation of Article 3 of Geneva Convention Act 1960 of Government of India could lead to capital punishment for grave breaches of conventions. Plea of superior orders will not relieve a person of his criminal responsibility unless he was legally obliged to obey orders, didn't know that the order was unlawful, and was not manifestly unlawful. The statute has rendered any statute of limitations non-applicable. The defense of the accused, being left with no moral choice, is subject to statutory construction, but a fair trial and right of the accused to standard defense is the bedrock of the ICC statute. The individual criminal responsibility has been excluded in the case of a person under 18 years of age, person who suffers from a mental disease or is in the state of intoxication or acts in self-defense, or one who acted under duress from imminent threat of responsibility and determines the applicability of the ground for exclusion. A mistake of law bearing the negation of the mental element required for constituting such a crime shall not constitute a ground for excluding individual criminal responsibility, whereas mistake of fact could be. As the rules of procedure and evidence have not been applied so far and have not tested water, the ICC jurisprudence is in the making, and in the process, the multi-civilization and geographical representation of legal values have to be fully utilized. The Government of India's lackadaisical approach towards its ICC involvement would not contribute much to the emerging ICC jurisprudence. She would simply range from the ICC universal jurisprudence, but she cannot forever miss the bus. The general principles of the criminal law of the one statute have crystallized nulla crimen sine lege, that is, the crime must be within the jurisprudence of the court and shall not be defined by analogy. Nulla pona sine lege means punishment shall be in accordance with the statute, and non-retroactivity ratione personae, no jurisdiction over conduct that precedes entry into force of the statute. there is no criminal responsibility under the statute for a person's conduct that doesn't constitute a crime within the ICC's jurisdiction at the time of its commission. Besides, a person convicted by the court may be punished only in accordance with this statute, and no person shall be criminally responsible under the statute for conduct prior to the entry into force of the statute. The jurisdiction of the ICC is yet materially emerging by incorporating the current development of human rights and humanitarian laws in substantial measures. The ICC has to assimilate human rights standards. Peace and security of mankind that remain the major concern of the UN could be the basis of international criminal law evolution. The International Law Commission Draft Code 1996 has enunciated crimes against the peace and security of mankind as crimes in international law. Article 2 of the ILC draft entails individual criminal responsibility of person who commits a crime against peace and security of mankind. The near future development would crystallize the crime of aggression in more details. The effectiveness of the ICC system would depend on a couple of factors, including the level of international cooperation it could arouse and receive, the political resolve to the states in prosecuting offenders of serious international crimes. The USA and India make subversive attempts to erode ICC jurisdiction till so far. This historical role that the ICC would play in all regions of the world is significant. It is a watershed in our civilization benchmarking. We now turn to Asian scenario. South Asia has remained a theater of the last World War, regional wars, several armed conflicts, both international and non-international, and a number of armed national liberation movements, a couple of which had endured for half a century. The International Criminal Tribunal for the former Yugoslavia, in brief ICTY, was established by the United Nations Security Council, acting under the powers conferred by Chapter 7 of the Charter of United Nations by Resolution number 827 adopted on 25 May 1993. The Security Council created the ICTY in response to grave concern over the reports of widespread and flagrant violations of international humanitarian law within the territory of former Yugoslavia, including reports of mass killing, massive organized and systematic detention and rape of women, and the continuance of the practice of ethnic cleansing, and also in response to perceived threat to international peace and security resulting from these violations. The ICTY is located at The Hague in the Netherlands, and its stated objectives include bringing to justice persons allegedly responsible for serious violations of international humanitarian law, rendering justice to the victims, further deterring violation of international humanitarian law, and contributing to the restoration of peace by holding accountable persons responsible for serious violations of international humanitarian law. The jurisdiction of the ICTY is limited to the commission of the violation of international humanitarian law within the territory of the former Yugoslavia since 1991 by natural persons, therefore excluding acts by organizations, political parties, and other legal persons. The ICTY has power to prosecute grave breaches of the Geneva Conventions, violations of the laws or customs of war, genocide, crime against humanity, include murder, extermination, enslavement, deportation, imprisonment, torture, rape, persecution on political or on religious grounds, and other inhuman acts. The ICTY possesses jurisdiction concurrent with that of the national courts, with that of national courts with respect to prosecuting serious violations of international humanitarian law, but it has primacy over municipal courts and may request that municipal courts defer to its jurisdiction in proceedings. The International Criminal Tribunal for Rwanda (ICTR) was established by the Security Council by Resolution number 9955 adopted on 8 November 1994. As with the case of the former Yugoslavia, the Security Council created the ICTY in response to its grave concern at the reports indicating that genocide, another systematic, widespread and flagrant violations of international humanitarian law had been committed in Rwanda, and for the purpose of contributing to the process of reconciliation in Rwanda and the maintenance of peace in the region. The ICTR is located in Arusha in the United Republic of Tanzania and has the stated objectives of bringing the perpetrators of the massive ISL violations to justice, as well as addressing the threat to international peace and security posed by the situations in Rwanda. The jurisdiction of the ICTR is restricted to the commission of serious violations of international humanitarian law in the territory of Rwanda, and Rwanda citizens responsible for genocide and other such violations committed in the territory of neighboring states between 1st January 1994 and 31st December 1994. The tribunal's jurisdiction is limited to natural persons and allows prosecution of genocide, crime against humanity, including the same categories as the stated of ICTR, but including the additional ground of racial persecution and violations of Common Article 3 to the Geneva Convention. The ICTR possesses concurrent jurisdiction with national courts, though it holds primacy as the ICTR. The Nuremberg Tokyo tribunals, the ICTY and ICTR also could surmount the judicial issues arising out of the mixed issues, and the evolving ICC jurisprudence would resolve any ambiguity at a time when it has to make decisions. The mechanisms of the Assembly of State Parties is capable of reviewing the Rome Statute as and when it is found necessary. The non-state parties can assist the ICC function, and the successful functioning of the ICC depends considerably on the level of international cooperation it can anticipate in the days to come in the near future. It may be added that in South Asia, Nepal, Bangladesh and Pakistan have become signatories to the Rome Statute among a handful of powerful states that evade the ICC jurisdiction. The USA and India take the lead by signing on 26 December 2002 an agreement whereby, without express consent of each country, no national offender of the ICC Copa Delicit could be surrendered to any international tribunal. ICC's jurisdiction, however, remains universal.